You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you've watched any cop show, you know these words by heart. But where did they come from? The story begins in the Arizona desert in 1963, with a crime that would ignite a national debate about the balance between law enforcement and individual rights. On March 2, 1963, 18-year-old Patricia Weir was walking home after her shift at a movie theater. The streets were dark and quiet. A car pulled up behind her, and a man grabbed her, threatened her, and forced her into his vehicle. He drove her to the desert, where he raped her, and then abandoned her on the roadside. Patricia survived and immediately reported the crime, providing police with a detailed description of the attacker and his car. 10 days later, police received a tip. Patricia's brother-in-law had spotted a car matching her description and recorded the license plate. It belonged to Twyla Hoffman, who lived with 22-year-old Ernesto Miranda. Miranda, who had an 8th grade education and a prior criminal record, fit the description perfectly. Police arrested him and brought him in for questioning. Patricia identified him in a lineup, confirming he was her attacker. Then came the critical moment. Miranda was taken into interrogation room number 2. For 2 hours, 2 police officers questioned him. He did not have a lawyer present, and the officers never informed him that he had the right to remain silent, the right to an attorney, or that his statements could be used against him in court. After the interrogation, Miranda signed a written confession. At the top of the confession was a typed paragraph claiming he had made the statement voluntarily, but the officers later admitted in court that they had never explained his legal rights. Miranda had no idea what protections he was entitled to under the Constitution. Miranda was convicted of kidnapping and rape and sentenced to 20 to 30 years in prison. His court-appointed attorney challenged the use of the confession, arguing that it was involuntary because Miranda didn't understand his rights. The trial judge overruled the objection, and the conviction was upheld by the Arizona Supreme Court. The case reached the United States Supreme Court in 1966. The central question was whether the Fifth Amendment privilege against self-incrimination applied during police interrogations, and if so, what safeguards were necessary to protect that right. On June 13, Chief Justice Earl Warren delivered the decision. In a narrow 5-4 ruling, the court reversed Miranda's conviction. The ruling established that before any custodial interrogation, police must clearly inform suspects of their rights. The right to remain silent, that anything said can be used in court, the right to an attorney, and that one will be provided if the suspect cannot afford one. Chief Justice Warren explained that being in police custody creates an inherently coercive environment. Isolated from the outside world, pressured and surrounded by officers, a suspect may speak even without physical threats. Lawyers serve as a crucial safeguard to ensure interrogations comply with constitutional protections. The court reviewed police manuals and found that interrogators were trained to use psychological tactics to break down resistance. Without these warnings and the presence of counsel, suspects could be forced to incriminate themselves unknowingly. The ruling was deeply controversial. 4 justices dissented, warning that it would make it harder to prosecute criminals. Justice Byron White criticized the majority, saying their distrust of confessions could return dangerous criminals to the streets. Law enforcement officials protested, arguing that solving crimes would become nearly impossible. Richard Nixon made opposition to Miranda a central part of his 1968 presidential campaign, claiming the decision was soft on crime. Congress even attempted to overturn the ruling by restoring the old voluntariness standard, but this effort failed. Ironically, Ernesto Miranda was retried in 1967 without using his confession. The prosecution relied on other evidence, including testimony from his girlfriend, and he was convicted again. Miranda served his sentence and was paroled in 1972. Later, he sold autographed Miranda warning cards to police officers, turning a symbol of his legal battle into a form of income. In 1976, he was killed in a bar fight. In a striking twist of irony, the man arrested for his murder invoked his Miranda rights, stayed silent, and was released due to lack of evidence. Today, Miranda rights are one of the most recognizable elements of American law. From cop shows to everyday awareness, nearly everyone can recite them. Over time, however, courts have carved out exceptions, including public safety and impeachment exceptions, and rules requiring suspects to explicitly invoke their rights, rather than just remain silent. Research shows that while most people recognize the words, many do not fully understand their meaning or significance, and most suspects waive their rights during interrogations. Despite these challenges, Miranda v. Arizona remains a cornerstone of American criminal procedure. Those simple words, "You have the right to remain silent," represent a fundamental principle. Even when suspected of a crime, citizens retain constitutional protections. The case transformed policing, shaped legal standards, and continues to spark debates about the balance between individual rights and law enforcement authority. Miranda's legacy is complex, but undeniable. While some critics argue the warnings handcuffed police, supporters emphasize their role as a symbolic and practical safeguard against coercive interrogations. Decades after Ernesto Miranda, those words still echo in every police station and courtroom across the country, a reminder that constitutional protections are not optional, they are essential. Settings: use appropriate media. Make the background music cinematic documentary. Use a male, clear American voice for the narrator.